All right. And a question I guess I have. You have to jail up? Okay, we're on the record in the Bloom matter. We were waiting for Mr. Bloom to appear via Zoom since that was the court's last order. I have now been informed Mr. Bloom does not wish to participate via Zoom. So we're going to have a problem. And it's not going to be my problem. You may.
When we heard the last hearing, I understand my client had several outbursts where the court removed him from the courtroom, but she also gave me a chance that if I could rehabilitate him, that he could be present in the courtroom. Now, I met with Mr. Bloom. I believe he's rehabilitated. I would ask that he be allowed to be in the courtroom. Things have changed.
Let me just say this. I'm not going to have Mr. Bloom try to control these proceedings. That's my job. And so if Mr. Bloom wants to be part of this proceeding, then Mr. Bloom will appear via Zoom. If you want to then make your argument for him being in the courtroom, you may make your argument at that point. But if he is refusing to participate as the court has directed, I have an option. I can proceed without him. He has forfeited his right. Or I could adjourn it out till he is fully rehabilitated and understands how this court works. Those are really the options, Mr. Kilmore. I'll let you say what you want to say, but those are the options.
Your Honor, I met with him last night. Things have changed somewhat drastically in that Ms. Blaisdell is not going to testify today. She has COVID. So we only have one officer who's going to testify to the other case, the obstructing the officer's case. Again, I met with Mr. Bloom last night. He gave me tons of notes, which I reviewed last night. I expected him to be by my side. Your Honor, I asked if he was rehabilitated. He said he would abide by the court's ruling he was rehabilitated. I again am asking that he be present in the courtroom today.
This court will not be held hostage to Mr. Bloom's antics. Doesn't work that way, Mr. Killowell. You know that.
Judge, I understand that. But what I'm saying is, can't you give this man a chance? I say he's been rehabilitated.
Whoa. When he was in this courtroom, he had like 8 chances. I didn't kick him out the first 5.
I agree with you.
And ultimately, it got to the point where he had to be removed. Then once removed, so that everything else is clear, he was fine for about the first 45 minutes. And then all of a sudden, tells an absolute fabrication to the court to try to get himself back in here, saying he can't hear. Problem is, he didn't know there was a deputy behind him. I asked the deputy, and the deputy, he could hear clearly. I'm not playing his game. This will get done with or without it.
I'm not asking you to play games, Judge. What I would say is, I don't necessarily disagree with you last time. Would you give this man a chance? One time, or give me a chance to go down to the jail. Again, Your Honor, I thought he was going to be by my side today on a short matter with one of the police officers, Your Honor. I either have to give me a chance to go down to the jail and talk to him and explain what's going on, or bring him into the interview room so I can at least tell him what's going on. I think he deserves a chance.
You got half an hour. You can go down to the jail.
Pardon me?
You can go down to the jail.
Thank you, Your Honor.
Court is standing in recess. Sorry, folks. Court calls cases of the people of the state of Michigan versus Bloom.
Good afternoon, Your Honor.
All right. And Mr. Killowell, your conversation with Mr. Bloom.
Your Honor, I had a chance to speak with Mr. Bloom. I explained to him that he will not tolerate any antics or any outbursts. He said that he would be willing to abide by your court rules, and I'm asking you to reconsider or barring the courtroom and give this man one last chance. I do need him for his guidance and management from the officers are satisfying. So I should reconsider the decision. I believe Mr.
Well, Mr. Bloom won't even get on Zoom for my decision.
Well, Your Honor, this is tough for me to say. He said he would not do it by Zoom. So I said I would ask the judge to allow me to appear in the courtroom.
Do the people have a position?
I'm not going to look at the court's discretion. I did indicate to counsel and your staff earlier that we are not able to proceed on a continued CSC exam because that's the testimony like that. But we are ready to proceed on Deputy Vice President.
Mr. Kilwald, I gave your client a number of chances and he's just playing a game with this. So I'm just not going to bend on that.
Your Honor, again, I have to object to the ruling for what that's worth. It's hard for me to proceed without a client. So
You did just fine with cross-examination of the witnesses when he was removed for his behavior.
I understand, Your Honor, but I believe my client has been rehabilitated and deserves at least one chance to be in the courtroom. I don't expect you to put up with any answers. I told him any outburst, you're out.
So keep
you
your
deserve that chance.
So he's there, ready to sign it. Is it shut off? Did we remove that at some point?
No, not to.
Hello. You're muted, Judge.
I am. Hello.
Hi.
Is Mr. Bl-
He is here.
Okay.
He's claiming that he's not going to come in because it's on Zoom.
And my attorney advised me that if I didn't have a preliminary, that not to do it on Zoom, so.
Well, so that the record is clear, I had removed this defendant from the courtroom, had advised counsel that we would be proceeding by Zoom. So he's going to have to make a choice of the choices I gave you, Mr. Kill. And that is that he can either decline to participate and we will proceed, or he can participate by Zoom. Those are his options.
So I can speak. So can I speak?
Go ahead.
If you want to, Mr. Bloom.
Mr. Simpson,
That's Judge Simpson, and you'll need to be on camera.
Your Honor, I don't have to be on camera. I refuse to be on camera because Mr. Kilwald, I don't mean any disrespect, Your Honor. I think you're a highly, highly efficient, very intelligent judge that has been around here a long time, and as well as you know I have. My qualm with this is because Zoom, at the last hearing, Zoom was broadcast over the internet where the other victim and witnesses that weren't at the court weren't sequestered like was supposed to be. And it was on Zoom, which I'm aware there isn't an MCL number yet, but I'm sure within a year or two, there will be something precedent to where it's not allowed anyway, because I asked for a in-person sequestered witnesses and that didn't happen. I was violated. My rights were violated. I feel my rights were violated. And my attorney this time, I don't mean to take up time. Your Honor, I have anxiety and I've been really stressed out because as will be shown in the long run, no matter how many felonies I've got, no matter how many times I've been to prison, I will be exonerated from these crimes. There's no doubt in my mind. And I believe, honestly, that the reason that the victim did not, or the second victim, supposed victim, didn't show up for court and said she had a positive COVID is because a crooked doctor in IFSI gave her a positive COVID because she's on drugs and alcohol because she gets $2,200 a month and she's very addicted. She's very strung out. She cut her tether off. They're not making her get treatment. They know she drinks a half gallon of vodka every day.
Okay, so
Jeffrey, this is your turn.
This
Okay,
is-
all right, I'm done talking about that. What I have to say, Your Honor, like I said, I've got the utmost respect, and I've heard you are a very fair judge, very qualified to do your job, and that you have seen through the crap, okay? And you know what goes on in MC, and you know what's going on in them streets. So I'm letting you know now, though, that as my attorney said to you, I will be perfectly fine if you allow me to come back into the courtroom. But he advised me that maybe I shouldn't do this on Zoom. And I do feel myself that yes, I made a mistake. But like I said last time, I was put on Zoom when I wasn't even aware until I was kicked out of the courtroom that I was on Zoom, and that the witnesses were able to leave the courtroom and go out and talk to the other witnesses and pull up Zoom when they get home and show them, this is what I said. Now you need to follow along with this. Then you got the police officers going to arrest her.
Mr. Bloom, you don't know any of what you're saying even happened.
I don't.
Jeffrey,
Mr. Kilowald informed me.
Jeffrey, this is your attorney. Please stop talking. You're just making matters worse.
Okay, well, Mr. Kilowald, I put things in your hands.
And I'm going to ask the judge if we could do this hearing without Zoom. That's the judge's discretion.
And I said to the judge, Your Honor, I promise you, I will be cordial. I will be polite. I will not. I had a cold last time, so I did make a couple little snide remarks or whatever. And maybe it was your discretion. So, but the thing is, Your Honor, I don't mean to carry on, but use your judgment, Your Honor. And if you don't want me to be there, I have trust in my attorney that he will get the copy of the COVID test. He will get all the evidence needed to show that this victim did not show up for court because she does not want to show up for court, whether the police went and got her or not.
Mr. Bloom, from my understanding, although I have not heard from them yet because we were waiting for you to get here, there's an officer here who arrived to get the victim in this case.
Supposed victim.
And no, he arrived to do that.
To get a supposed victim, not a victim.
Okay. I've listened to you talk without interruption, and now you're listening to me.
Yes, sir. Yes, Your Honor.
And the officer saw the COVID test, from my understanding.
Did he take a picture?
I don't really care whether he took a picture. If he's going to tell me that that's what he saw, that's what he saw.
Okay.
And so that's not going to happen today. The other case that you're here on is prepared to go. Now, you can elect to participate or not, but I think you need to understand something very clearly, Mr. Bloom.
Yes, sir.
You do not make the rules. You will not sit here and say that somebody is violating your rights, that I guess being me, in some type of extortion to get your way. Wrong judge, wrong day, because it doesn't happen with me.
Well, I'm sorry you see it like that.
Plain and simple.
I'm sorry you see it like that, but that's not what I'm trying to articulate to you. Not at all.
So I just asked, and these are the rules that were set because they were set because of Mr. Bloom's behavior. So I will again pose the question as to whether or not Mr. Bloom wishes to participate. If he doesn't wish to participate, he doesn't have to participate. That's his call. But my intent would be to go forward.
Your Honor, on behalf of my client, again, you've heard him say that he apologized to Your Honor. He would like to be present in the courtroom. I would ask the judge to reconsider it, I believe, and relocate it. If not, I would ask that it not be broadcast on Zoom, which, again, penalizes my client, but I don't know what else to do.
I am not going to deviate for anyone from what has been this court's procedure. It will broadcast on Zoom. If necessary, it will proceed, or it will broadcast on YouTube. It will proceed.
Really?
Just please note my objection to my client.
I've noted your objection. I saw the email that was sent indicating that your client requested that the courtroom be closed without any statutory authority whatsoever to close the courtroom.
Your Honor, you're allowing the witnesses and the victims to see each other's testimony on Zoom. You're allowing witnesses and victims to see each other's testimony.
Your Honor, to Ms. Reiser's credit, I believe she did cite a court statute that would allow you at your discretion to close.
And my discretion doesn't mean that I will. And I'm not closing the courtroom. I'm not.
You're corrupt. You are in violation.
Oh, that's it. You're in contempt. That'd be 93 days. Anything else you want to say, Mr. Bloom?
Thank you, Your Honor. Mr. Kilowald, you can handle it. Thank you. Goodbye.
Thank you, Jeffrey. I appreciate that.
Just for the record, and I would like to indicate for the record and for counsel in the court, at the September 13th preliminary witnesses were sequestered. So
I know.
When Mr. Marshall was testifying, Ms. Blaisdell was sequestered outside the courtroom. She had no access to any electronics, so there isn't any way reasonable for her to have watched or seen Mr. Marshall's testimony. So the witnesses were sequestered and the officer in charge was present in the courtroom.
Your Honor, just very brief on that. We had a few breaks during, I think what my client is getting to, we had a few breaks during that time.
I can't even hear it. I can't even hear it. This is Nazi. This is Russia. I can't even hear what the prosecutor or my attorney are saying.
Mr. Marshall Brown was allowed to leave his stand, and I believe my client believes when he went out, he may have discussed that with the other witness. I think that's what my client is referencing. Just for the record.
This is corruption. I can't even understand what they're saying. Can you hear it? Can you understand it?
So the witnesses were sequestered at the September.
I know. The witnesses were sequestered at the last hearing. The witness was not in the presence of the other witness while they were testifying and did not have access to electronic devices in which to hear the testimony. And I heard that very clearly, and I recall that happening. The revisionist history that's trying to be placed on the record wasn't what occurred.
And in terms of going forward in 22 FB 1278, I do have Deputy Mace who is present today. The victim does not have transportation, so the Sheriff's Department was picking her up for the preliminary exam today. The second victim that needed to testify, Tiffany Blaisdell. She does have COVID. Deputy Mace made contact at the residence, saw the paperwork, so I'm happy to put him under oath to put that on the record. The positive COVID test that she had.
So she had a positive COVID test, and so that I'm clear, the positive COVID test was from a clinic or doctor or something along those lines.
Hospital discharge paperwork from Sunday, October 2nd, 2022. Correct.
With all due respect, we have an officer here. Can you please get on the stand and testify that I know Ms. Ryder, but she's just repeating what the officer could be saying under oath for the record, Your Honor.
In this wonderful world we're in, dealing with COVID every day, an officer's going to come report to the prosecutor that the alleged victim in a case has COVID and sees paperwork that's reported to you, and somehow or another that's going to be questioned.
Yes, Your Honor.
You got to be kidding.
No, Your Honor.
Let's do this. No, Mr. Kilowald, It's your bed. You're gonna lie in it. Officer, please take the stand. If you come forward, be sworn.
The other witness needs to question, Your Honor.
For the testimony on COVID?
Fine. I withdraw my report.
The two officers are president.
Are on the other case. This is about the,
CSC.
right. Let's have them sworn.
Raise your hand. You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, and help you God. Lower your hand, have a seat. State for your first and last name for the record.
Yep, Deputy Sean, SDAN, that's NBC,
Sure.
Can you tell the court where you're employed, sir?
Washington County Sheriff's Office,
In what capacity?
Deputy Sheriff.
And were you working today, October 4th, 2022?
Was,
And what was your second?
patrolling the Land Township.
And were you sent to Osmond's Way to pick up a victim on a case that you were there?
Correct, I was working informer that she had court today, a reminder that she had court today, for transportation.
And did you do that?
Yes, I did.
And did you make contact with Ms. Blaisdell?
Yes, I did.
And what, if anything, did she advise you?
Yep, when she came in the door, she advised me that she couldn't come to the court today because she had COVID. She showed me hospital discharge paperwork dated October 2nd, 2022. Paperwork is in the she had COVID.
That was October 2nd.
2022?
Correct.
And you saw that paperwork?
Yeah.
Okay, and how did she appear to you?
She appeared sick. She was coughing profusely. She sounded nasally and congested.
Thank you. I have another question.
Cross-examination.
Yes, Your Honor. Just a follow-up question. Is there a reason why you went to pick her up?
Yep, I was arrested by search warrants.
Do you know if she owns a vehicle?
I'm aware.
Okay. And how is it that you interacted with her? I mean, is she COVID right now? I mean, does she have COVID right now? And if so, I'm wondering how you approached her or discussed with her.
Yep, I knocked on the front door. She came in the door, and I spoke with her at a distance.
Okay. And she showed you some paperwork?
Correct.
And what was the paperwork that she showed you?
It was hospital discharge.
And from what hospital?
Trinity Health.
I'm sorry?
Trinity Health, St. Joe's.
Trinity Health? And did it show a doctor's name on there?
I don't know.
You don't know? Did you take a picture of that with your cell phone?
Did not.
Did Blaisdell appear in any way intoxicated or under the influence of drugs?
No, she
And how long have you been an officer?
wondered.
Thank you very much. I have no further questions.
All right. So that the record is clear, sir, you went to the door. She said she had COVID. You saw paperwork that indicated that she had COVID from a diagnosis or at least a discharge from St. Joe's Hospital of October 2nd. Correct. And as she appeared to you, she was coughing, nasally sneezing. Did you have any reason whatsoever to doubt that what she was telling you was true?
No.
Thank you. You may step down.
And we would request a continuance at 22 FB 1278. The court's next available date. I don't know what the quarantine is now. For the CDC, maybe at least 5 days at the same.
Well, yes, kind of, but I don't know that we're going to be able to get you in 5 days.
Right,
So I don't
think we're gonna-
I don't think that's our issue. Our issue is going to be more finding a date. So in 1278, preliminary examination is adjourned to November 1st, 2022, 1 p.m.
And we are ready to proceed in 22 FB 1276. And then we have Deputy Bob, OIC, to my left, and my first officer, Deputy Trevor.
Okay, hold on one moment. Mr. Kilowald, your client has, I guess, determined not to participate. How would you like to proceed, sir?
Your Honor, I've made my objection of him not being in the courtroom. I don't know what else to do, Your Honor. I guess I could object to this hearing further, because not participating. I'm supposed to advocate on his behalf. I would say, I understand that he said I can't be in the courtroom. He's still on page, I'm a good attorney, I can't listen to the problem, I was asked to the court during this matter.
As they have sat down here all afternoon, would the officers be available on that November 1st date?
So they are both available that day, but so we, that like they're on their shift right now, so we have half of the Ipsy Township patrol has been sitting in court for 3 hours. So my preference would be to finish it, do it today. I mean, we'll be kind of running into the same situation again on November 1st.
I don't know if we'll be running in. I mean, with them being here, I get that. I don't know if we'll be running into the same circumstance, but I'm sure, as you can appreciate, given Mr. Bloom's outburst, I'm trying to balance things and what Mr. Killewald has said. So I am going to adjourn the proceeding. What I will do, however, so that my order can be clear, and if Mr. Bloom at that time elects to do what he has done today and not to participate or participate from afar, that's going to be his choice. I've given, as I said at the end of the last proceeding, I would certainly reconsider allowing him back in the courtroom. However, that is off the table at this point, because he has shown by his behavior today that he cannot conduct himself appropriately. So his choice will be that he can participate via Zoom, or he can elect not to participate at all, and we will continue with the proceeding with him in absentia. He has plenty of time to attempt to try to gather an understanding as to how this court is going to operate. And so if he has time to figure out what his decision is. If there is a request, Mr. Killewald, well, I'm making it clear that's where this court is going. If there is a decision that he wishes to do that, that will need to come by written motion to me as to all of these supposed promises that he's making as to how he will conduct himself. But that doesn't mean I grant it, and right now I am predisposed not to.
You're saying he wants to be in the courtroom, I have to file a motion.
Absolutely, because my ruling now is that he will not be in this courtroom.
And it's my understanding he gave him,
I get held him in contempt, summary contempt, 93 days.
is that something I can argue in the motion? Or?
If you'd like to, you may, but you can argue whatever you'd like.
Thank you, Your Honor.
So, and to the deputies, this court doesn't like to waste time, but I apologize to you for the delay and not being able to go forth today. But I think you also can appreciate I'm trying to balance certain things here.
Judge, could I just ask one other question? Is there, and again, I probably let's say ask this, but is there another possible date later in the week in case my trial goes that we could have an alternate date that's set, that if my trial goes, it should be done by Wednesday?
Later in the week?
Yes, no.
Okay, so later in the week, that's not going to happen.
Okay.
My Wednesday is full of townships things. My Thursday is full of every PCC, which you know, and my Friday would be full of a housing docket. So that's not going to happen. It's going to have to be a Monday or Tuesday. That's the only way it will happen.
Could we set an alternate date for and again, I apologize to everybody, but could we set an alternate date of November State, Your Honor, Tuesday.
All right, November 7th, 2022, at what time you want me to do it? At 9 a.m. And so, Mr. Killawald, you're requesting that both hearings be set to that time.
Yes, Your Honor, and I do appreciate everybody's consideration, especially the officers. I do apologize. Now I said, hopefully my trial is off, but if it doesn't, it's November 7th is perfect for me.
At 9 a.m.?
Yes, at 9 a.m. It'll be in the morning.
On November 1st. Thank you, Your Honor, and I will anticipate getting you a motion within the next several weeks.
And I will look forward to reading it. Folks, thank you. And again, to the deputies that took their time, my apologies. All right. Is that it for us? Those are my notes. 14A stands adjourned.